United States versus Winans is the 1905 case. And remember, it's peculiar because it's right in the middle of the allotment period, but it's considered a win for sovereignty. And that's the one that was, the concurring opinion was written by Justice Joseph McKinnon, or Justice Joseph, that's hard to say, Justice Joseph McKenna. And he began to sort of outline the what is referred to as the Indian canons, or the Indian canons of construction. So it's held up as an important case for that in this chapter. It's about fishing rights. In fact, you got 3 cases. In fact, there are many more cases than that regarding fishing rights in the state of Washington. And I noted some typos in there. Remember that Washington statehood was 1889, not 1898. So that's kind of confusing if you read through there. Anyway, it was a win because the Supreme Court Justice, Mr. Justice McKenna, found that this was an 1855 treaty. The wording in the treaty, of course, was English. It was also legalese English, right? And there were a couple of issues with sort of the legitimacy of the treaty, or at least the fairness of the treaty. Number one, the treaty was negotiated before anything was written down. It was negotiated using English interpreted into a trade language known as Chinook jargon. It has a more a nicer name these days, but I can't recall it off the bat. Wawa, I think it's Wawa, something like Chinook Wawa. Anyway, so this is a trade language of only 300 words, something like that. Number 2, there was a lot of technical, sort of vague language in the treaty. Now, depending on who was interpreting this, it could have gone either way. But what McKenna did was he set out some standards. And those standards were, well, you tell me, we've talked about them enough, and you've read about them by now. Remember what those sort of standards were, the Indian canons, essentially?
Treaties should always be interpreted as they would have been understood by the Indians of the time.
Excellent, Kawhi, that's excellent. Treaties should have been interpreted, or should be interpreted in the present as much as possible, in as much as we can possibly understand them to have meant to the people at the time. You said it better than I did. So that's one. Another one that's kind of related to that is place this treaty within the historical context of the time and try to forget about anything that happened after the treaty. In other words, try to forget about any of the development of the area after 1855, the development of the state of Washington, the homesteading of non-Indians into the area. Forget about that, because nobody knew about that at the time of the treaty. And number 3, take the language for face value, essentially. Words within a treaty, and this is a standard across any legal interpretation. Anyway, the courts consider every word of a treaty to be important, and none of the words in a treaty are unimportant. Okay, so we can't just say, well, this part is kind of contradictory to this part, so we'll discount this part. Can't do that. So it's very much refereeing, trying to interpret the most accurate event and the most accurate understanding of things. And so what McKenna said was, in so many words, that the United States is the one initiating the treaty. It's initiating the treaty to get land. for a land cession. That's clear. Our motives are clear. The native peoples are the people who are going to be giving something, all right? And we're trying to sell them on this. So whatever the treaty states, so perhaps even so somewhat vaguely, we have to consider that there were language issues, and that more than likely, the native peoples understood it to mean whatever it is in their favor. Okay? So that's kind of the standard. It's not caving to a side that has historically been marginalized and, even underwent cultural and even population genocide in some cases. Okay? But it's just trying to interpret things in the most accurate way, most fair way. So that's Winans, very important one. And did I miss anything on that? Yeah. Mm-hmm.
So seeing I read the book, kind of like those three rules, it's actually on the top of that page, is the third point. Treaties must be liberally construed in favor of the Indians.
Yeah, that's your author saying that. And I don't really see how those are the canons necessarily. I mean, I think he's trying to give you some shorthand, basically that treaties must be liberally construed in favor of the Indians. In other words, don't assume that the Indians were reading this in technical language. Assume that, what sort of says that they're getting, they assume that they were getting. So you can't throw linguistic technicalities at the other side. That's pretty much what I think it means. And any ambiguities, and this is pretty much the canon now, any ambiguity has to be resolved in favor of the tribe or the group. And you saw Justice Gorsuch do that. He's done that several times, in fact. He's been a deciding vote. He was the deciding vote in the McGirt case, and he wrote the concurring opinion. And it was pretty clear that he invoked the Indian canons in that example. But if you haven't read it, read the both the concurring opinion and the dissenting opinions in the McGirt case. The Chief Justice, John Roberts, current Chief Justice of the Supreme Court, Roberts wrote a very, very long response, a dissenting response to Gorsuch's stuff. So it's amazing. A good friend of mine, colleague, who studies the same thing, a specialist in disestablishment, once told me, she said, "Have you ever gone to the Supreme Court and actually sat in on a Supreme Court hearing?" And I said, "Well, no, I've been to Washington 1,000 times, but I haven't done that." She goes, "You really ought to do it, because you realize that if there is any ultimate sort of power in the United States government, it's sitting on the Supreme Court. The Supreme Court has a lot of power, one individual justice. So sometimes, maybe there's a crusade going on. I don't know, but whatever." Well, this led to the Bolt decision. The Bolt decision is 1974, again, affecting the state of Washington, and this was something that was brewing for at least 10 years. The McKenna decision and Winans didn't change a lot for Native people who were fishing in the state of Washington. The state of Washington recognized that Native peoples didn't have to buy permits, but they still had to have some sort of permit that told others that they were exempt from the permit. So they issued these things called blue cards. You ever heard of those? Blue cards. And those were, it was, in other words, the state of Washington was still trying to enforce some sort of licensing system. And of course, throughout the middle part of the 20th century, tribal governments were very much in limbo during the termination era. But once the civil rights movement gets started, then you have a lot of people who begin to look at those treaties and look at those recent court cases and say, look, the state is still infringing, the state is still encroaching on tribal sovereignty, and let's do something about it. So this is the case that was prompted by fish-ins, all right, and intentional breaking of the state game and fish regulations in front of state game and fish officers to prompt arrests and that sort of thing. So it was following the lead of the civil rights movement that got started in the early 50s with lunch counter sit-ins and stuff like that. And, you know, it's referred to as nonviolent civil disobedience, or just civil disobedience, but nonviolent civil disobedience. Although the fishing stuff kind of got violent sometimes. You know, the African American who held boycotts and picketed restaurants and stores in downtown areas in the South, they got their share of blowback from whites. They did, and they dealt with a lot of violence during that period. Native peoples in this era also had experienced the rise of anti-Indian groups, anti-Indian white supremacist groups. If you're interested in a project, a topic, it's very interesting, and it's not written about that much. And there are a lot of good sources on it, like the Southern Poverty Law Center. Ever heard of that in Alabama? It's run by a fellow, or I don't know if he's even alive anymore, Morris Dees. Got started early on in the civil rights movement, but they are the sort of clearinghouse for tracking hate groups and white supremacist groups. Of course, it's probably expanded greatly now since the last several years. Anyway, so that's and so in the United States versus Washington, this was a district judge by the name of George Hugo Bolt. So it's referred to as the Bolt decision. And the Bolt decision it was brought about through, it took a very long time for this court case to end. It got started with lots and lots of back and forth by the state of Washington and basically the Game and Fish Department of Washington against the Department of the Interior representing the tribe. So, and so what it winds up being is more interpretation, use of the Indian canons of construction, and was it a win for tribal sovereignty? You remember? Well, let's just look here.
When I read this, I kind of just was kind of confused because he, like in the end, he just kind of says, like, well, why took away was like 50-50 decision of all harvestable fish, and I'm just like, well, that's kind of lost because how do you say this is 50% of the fish that's available unless you already catch it?
Right. So essentially, what the judge did was he said, okay, according to the treaty, there is, it sounds like native people and non-Indians will have equal access to the resource, and so he recognized the native interest in the fishery resource but he also recognized the non-Indian interest in the fishery resource. And by doing that, he sort of forced, and later on they required basically the native groups to engage in fisheries management. Because this is really about fisheries management. And so this was actually one of the very first examples, the first that I know of, where a court case pretty much told the states and the tribes, get along with each other, work something out. And so it created a framework where tribes are invested, or they're vested in the resource and managing the resource with the state. So it's kind of what we're moving toward now, states and tribes cooperating with one another, having maybe overlapping jurisdictions or separate jurisdictions. And in that sense, if you want to take that a little step farther, like I think I did the other day, it's, by requiring the tribe to have this responsibility, right, for the resource, it is really it holds the tribe up as a recognized entity that has all legitimacy to manage the resource. So that's good for the long term in this case, I think. Now, a cougar den, any other questions on that? And it's pretty complicated. It's not the most complicated case we're going to talk about today, but it's pretty complicated. Cougar den is the example that your textbook author uses to sort of demonstrate that sometimes the use of the Indian canons can seem political, and that's their weakness. Their weakness is that these are only standards. These are standards that judges, are not required to follow, but through honorable dealings, kind of expected to. But sometimes they can be perceived as being political. But we've seen what that means. We've seen the rationale for, and there's really not an opposing justification for not reading a treaty and not taking into account the linguistic disadvantages and the contextual disadvantages that tribes had during the treaty process. Okay, I don't think you can make an argument for that. But so that's why it's generally recognized. Good judges will not allow technicalities to rule. They're going to go for the spirit of the treaty. Well, cougar den is what was cougar den? Do you remember? It was a fuel wholesaler that was owned by a Yakima, or owned by a group of Yakima members. It was a company that was incorporated under Yakima law within the Yakima system. I say Yakima, I think that's proper. And the operation was based within the Yakima Reservation. And what they did was they supplied gasoline to the local tribal retailers within the reservation only. So this was completely Indian country, all right? Absolutely no question about it. Therefore, the state didn't have any access to taxing this business. Okay? Nevertheless, tax commissions can be sneaky, all right? And initially they attempted to tax the inventory of the fuel wholesaler of Cougar Den. They attempted to tax their inventory. Well, they can't do that. Everybody knows that. You can't tax. The state cannot levy a tax against inventory that's completely contained within Indian country. So what they did, and Oklahoma did the very same thing, or something like it recently. What they did was to say, okay, we can't tax the retail sales, That's all in Indian country. So even anybody who is non-Indian can drive into the reservation, fuel up, and leave, and not pay. Essentially, they're not going to be paying the state tax. Kind of like when we would order things from Amazon several years ago before they implemented the retail sales tax. It was great, wasn't it? Because you got everything cheaper, didn't have to pay sales tax. But no longer is that the case. So the state is going, okay, well, how can we tax these? How can we tax this gasoline that's, most of which we assumed is probably being purchased by non-Indians and being used on state roads outside the reservation? Well, they said, well, okay, let's place the tax on the transport of the fuel. Okay, so if it enters the state, the moment it enters the state, crosses the state boundary, crosses into the state, then it is liable for the state tax. That's what they said. And that would go whether or not it came by pipeline or truck. Of course, most of it comes by tanker truck, or by ship. That's possible. That was the argument made by the state. Okay. Now, this is one of the better oral arguments. The oral arguments of Supreme Court cases usually last for at least an hour or 10 minutes sometimes. But if you want to, I would recommend listening to this one. It's really a good one, in that the state of Washington winds up trying to convince the justices, and remember this is a fairly recent case, 2019, so all the current folks are there, right? Well, except for Ruth Bader Ginsburg, she's not there. Or wait, she may have been, I think she was gone by that time anyway. So what the state of Washington is saying is that, okay, as soon as that fuel shows up, it's taxable. And what the tribe did, what the Yakima tribe did, is they went back to the 1855 treaty. 1855 treaty says, just like it says that the tribal members retain the right or reserve the right to fish at all the usual locations equally with the non-Indians. Okay. Well, what the wording in this treaty said, the Yakima Nation reserves the right, in common with the citizens of the United States, to travel upon all public highways. Okay. And public highways at that time included, just a few roads, 1855, but essentially this is saying that, Native peoples can't be barred from those roads, and that they have the right to take, actually it doesn't say it in here, he didn't quote all of it, I don't believe, but the quote is actually more interesting. It says, they have the right to use the public highways to take their goods to market. And that would include things like livestock, to drive cattle to the market, or to purchase things and bring them back to the reservation. And they can do that, as it says, they have the right to do that. And so the question was, if, what was the fuel that was being taxed? Was it, and so the state was saying, we're just taxing the fuel. We're not taxing the transportation of the fuel. We're just taxing the fuel. Once it comes in, it's taxable. And the Supreme Court was saying, no, the way we interpret this is that you're taxing commerce between Native peoples, sovereign nations, and whatever they're wanting to do. And that's the purview of the federal government only. So, taxing movement. And so, it was an interesting argument. And eventually, the Cougar Den prevailed in that case, which they should have, I think. I mean, how else are you going to be able to get fuel into the reservation? You can't. They have no fuel. They have to bring it in somehow. So anyway, any questions on that? It's a sort of convoluted but interesting case. It's interesting to hear how the state tries to reason and fails. Okay, Dion, we've talked about. I guess, we've talked about all these, haven't we? I'm sorry. All right, I'm wasting your time. What's the story of Dion? Remember that? Or we're just reviewing anyway? What?
Eagles.
Yes, the Eagles. And what was so the U.S. Fish and Game Service set up a sting operation to try to figure out where the source of the eagle feathers on the black market. They traced it back to these fellows on the Yankton Sioux Reservation, and they caught them red-handed. And they were able to get, of the 20 carcasses they found, they were able to use 4 of them for evidence. And basically they charged these guys, and Dion was just the name, the ringleader supposedly. They charged him with 3 counts of breaking 3 federal laws. So they're not breaking any state laws. They're violating the 1962 Eagle Protection Act. They're violating, the Endangered Species Act, 1973, and the Migratory Bird Migratory Bird Treaty with Canada, and basically the Waterfowl Migratory Bird Treaty. So, of course, the thing you need to remember, well, a couple of things you need to remember. What was and this is less important. What was the defense that Dion tried to use? The 1858 treaty that allows hunting, all right? Allows hunting of, he didn't use religion, but the fact of the matter is he was caught doing this for commercial purposes. And so he wasn't charged on that, but he was caught doing that. So he tried to go for, this is I have hunting rights on my reservation, you can't change that. And in fact, it's the federal government and they can. So Congress can. So the question for this important part of this is whether or not Congress can subsequently change or abrogate a treaty, or at least portions of a treaty. And in this sense, the court ruled that yes, absolutely, the Congress, in making later laws that have specific purposes, will supersede Indian treaties where they're contradictory. Okay? And there are some good reasons for that, but the United States was utilizing a precedent. This was in 1986. The precedent was, of course, Lone Wolf versus Hitchcock. In other words, Congress may make, later laws, it may change things, but it has the power, plenary power, to abrogate treaties. So that was, in a sense, I guess you could say, who wins there? Well, the Eagles win. The Eagles win, I guess. But the thing is, Dion was actually, a pariah on the reservation. He was, it brought terrible press, and nobody approved of what he was doing, especially people who actually, were traditionalists who utilized eagle feathers. They didn't want. They called him, he was just a poacher.